You filed a notice of appeal, or you're about to file one. To support your appeal, you need a record of what happened in your trial court case. The record is a very important part of an appeal. Think of the record as a file that contains all the information the Court of Appeal needs to know about your case to make a decision about your appeal. It's important to know that the Court of Appeal does not automatically get a copy of the record from the trial court. You have to make it happen. This video is about how to get the record for your appeal. In legal terms, this process is called designating the record on appeal. So, how does it work? First, you look through the trial court record of documents and what was said in your case. Then you designate or choose what parts of the record the Court of Appeal needs to decide the issues you raised in the appeal. Keep in mind, in your appeal, you can only talk about things you put in the file you send to the Court of Appeal. So be sure to designate all parts of the record that you want the Court of Appeal to know when it considers your appeal. The deadline to designate the record for your appeal is usually 10 days after you file your notice of appeal. There may be an exception if your case is being considered for mediation. But in most cases, if you miss this deadline, the trial court clerk will send you a notice of default and give you a few extra days. The court will also send you a notice of default if you make the original deadline, but there's a problem with your request to designate the record. Either way, if you receive a notice of default, it is best to meet the deadline in the notice because the trial court cannot give you any more time to designate the record. If you miss the deadline in the notice of default, your appeal may be dismissed, or you may be able to apply for an extension with your Court of Appeal, but they do not have to grant your request. You can find information on our website about how to file your notice designating the record with the trial court and how to serve a copy to other parties in your case. Now that we've reviewed the process for designating the record, let's discuss how you'll do it. To designate the record on appeal, you'll use Form APP-003. This form is called Appellants Notice Designating Record on Appeal for an unlimited civil case. For the rest of this video, we'll be talking through each section of the form, so it will help to have a copy with you while you watch. You can download Form APP-003 from the California Court's website, www.courts.ca.gov. Once you're on the website, go to Forms and Rules, then go to Browse All Forms. Select the Appellate category, and you'll see all the forms you'll need for the appeal. On our website, you can also find definitions of the legal terms we talk about here. We're going to focus on the sections of the form that are needed for most appeals. Let's start with Part 1, the record of documents filed in the trial court. Look at boxes A, B, and C. You'll check only one of these boxes to choose how the trial court documents will get to the Court of Appeal. Box A is for a clerk's transcript. A clerk's transcript is a collection of documents from the trial court file that are prepared by the trial court clerk. There are many advantages to a clerk's transcript, and it's the easiest way for an appellant to get documents. That's because the trial court clerk does all of the work copying and organizing the documents. The clerk also files the documents and an index or list of the documents with the Court of Appeal and sends you a copy of everything. If another party wants a copy of the clerk's transcript, they would need to pay for a copy. Box B is for an appendix. An appendix is also a collection of documents from the trial court file. An appendix is like a clerk's transcript, except that it's prepared by a party to the appeal. The main advantage of an appendix is that you do not pay the court clerk to prepare your documents. But there are many disadvantages. It takes a lot of time to create an appendix, and it can be difficult. You or your lawyer must get copies of all the documents you want to include in the appendix. You may have to pay the trial court to get copies of documents that you do not already have. You must follow the court rules to organize the documents in order by date and then add page numbers. You also need to create a chronological and alphabetical index or list of all of the documents. Plus, you must file the appendix with the Court of Appeal when you file your appellant's opening brief and pay to serve a copy of the appendix to all the parties in your case. If you do not do everything correctly, the Court of Appeal will reject your appendix and you will have to fix it. If you choose to electronically file an appendix with the court, you'll also need to follow the special electronic filing rules for your Court of Appeal. If you're considering filing an appendix, it's a good idea to review California Rule of Court 8.124, so that you can see all of the requirements. Moving on, Box C is for using the whole trial court file, just as the clerk of the trial court keeps it. This is the quickest way to get your record on appeal. This may also be the cheapest way to get documents to the Court of Appeal, but it can make writing your brief harder because you'll have to read through the full trial court file, not just the parts you need. In the trial court file, documents are put in chronological order, which means they're in order by date. Many trial courts keep a list of all the documents. This list is called a register of actions. The trial court file includes a list with the names of all the attorneys in the case, the parties they represent, and any parties who do not have a lawyer. If the appellant chooses to use the whole trial court file, the trial court clerk must send a copy of the index to all attorneys in the case and any parties who do not have a lawyer. Note that the 2nd, 5th, and 6th District Court of Appeals do not allow you to use the whole trial court file. And in all other districts, if you want to use the whole trial court file, you must have what's called a stipulation, which is a written agreement signed by all parties to the case. You must file the stipulation in the trial court with Form APP-003. When you decide how you want the record of trial court documents prepared, check box A, B, or C. If you check A, don't forget to check box 1 below it if you can pay for the clerk's transcript, or box 2 if you cannot pay. If you check box 2, then you must check one of the boxes below it. Pick A if you already have an order excusing you from paying court fees, or B if you need to get one. If you have a fee waiver from the trial court, you can use it to avoid paying a fee for the documents in your record. Check to make sure your fee waiver has not expired. If you need a fee waiver, use Form FW001 from the California Court's website. You can find the fee waiver form, along with instructions on how to fill it out, in the fee waiver category on the same section of the website where you got Form APP-003. Now let's talk about Part 2, the record of oral proceedings, meaning what was said in the trial court. In most appeals, there are 2 choices here. You can check box A if there were no oral proceedings, or you do not want a reporter's transcript. You should know, if there were oral proceedings and you do not provide a record of what happened in them, the Court of Appeal may not be able to consider the issues in your appeal. This means you may lose without being allowed to make your points to the court. So only check box A if there were no oral proceedings, or if you have determined by study or legal advice that you do not need a record of them. It's important to know that in almost all civil appeals, the trial court hearings are not reported unless a party in the case hires a court reporter. So if there were oral proceedings in your trial and you cannot get a reporter's transcript, another video explains what you can do. If there were oral proceedings in your trial, and a court reporter made notes of what was happening, and you want to include the reporter's transcript in your appeal, check box B and box 1 underneath it. Next, you'll need to choose how you'll pay for the reporter's transcript. If this is the first transcript that has been prepared, and if you can pay for the transcript, you'll probably check subbox A. A fee is charged for each day of transcript. The daily fee is determined by how long the court was in session on your case that day. Talk to the court reporter or the appeals unit in your trial court about the amount of your deposit. You can find a list of deposit fees online in California Rule of Court 8.130B. The actual cost is often less than the deposit, so you usually get some of the money back. Sometimes a court reporter will waive the deposit if you promise to pay them directly. If the court reporter in your case will make that agreement, get a written waiver of a deposit and attach the waiver to Form APP-003. Then you can check subboxes C and 1 and not make a deposit to the court clerk. If you already have a reporter's transcript that the court reporter prepared and certified as official, you can file it with Form APP-003 and check box D. There may be an additional cost to put the transcript in a new format for the Court of Appeal. If there were oral proceedings but you cannot afford a reporter's transcript, check box B. If there were oral proceedings but no court reporter took notes, or if you cannot get a transcript paid for by the Transcript Reimbursement Fund, you may need an agreed statement or a settled statement. In this case, you would check box B2 or box B3. You can learn about agreed and settled statements in another video on this website. The next section of the form is Part 3, Record of an Administrative Proceeding. You can skip this part unless your case is about something that happened in a government agency like the DMV, a city council, or a planning commission. If your case was for review of an administrative action, designate the same record of what happened in the government agency that was used in trial court. Now let's move on to Part 4, where you choose what you want in a clerk's transcript. You can skip Part 4 if you picked an appendix or the whole trial court file in Part 1. If you picked a clerk's transcript, you must fill out Part 4. If there's a register of actions for your case, it will help you fill out Part 4. A register of actions is a list of all the documents that were filed in the trial court. You may be able to download a register of actions from the trial court's website. If there is not a register of actions for your case, or if your trial court does not have a public download service, you may have to go to the trial court to look at your case file to fill out Part 4. Subpart A lists documents that must be included in a clerk's transcript. Do not cross out any of them. Below Date of Filing, write in the date that the trial court clerk filed each of the documents listed as 1 through 7. Some of these documents may not exist in your case. If they do not exist, just leave that area of the form blank. In Subpart B, you list all the additional documents you want to put in the record on appeal. Be sure to include all the documents you'll need for your argument in the appeal. You must give the date of filing for each document. If you have a copy of the document, write the title of the document in the Document Title and Description column. You do not need to write a description if you write the title. If you do not have a copy of the document, you can look at the Register of Actions. If the Register of Actions lists the document title, write only the title on the form. You do not need to write a description. If the Register of Actions does not list the document title, it will list a description of the document. So on the form, write the description and also write the document number from the Register of Actions. Attach as many pieces of paper to Form APP003 as you need to make a list of all the documents you want. It helps the clerk if each piece of paper you file has a heading that has a shortened case name, the case number, and a description, like Clerk's Transcript Additional Page Number, and include the page number. Next, you'll see Heading C, Exhibits to be included in a clerk's transcript. If no exhibits were offered as evidence at a hearing, you can skip this box. If exhibits were offered as evidence at a hearing, it is best to check the box and do your best to fill out the list of any exhibits you want in the record on appeal. For each exhibit you choose, be sure to include the number or letter the court gave to the exhibit. Sometimes the trial court keeps exhibits. If the trial court returned an exhibit that you want in the record on appeal, the party who has the exhibit must take it back to the trial court after you designate the record. That means if you have the exhibit, you must return it to the court. You should know that there is a way to give exhibits to the Court of Appeal later if the exhibits are not included in the clerk's transcript. Now we're at the last part of the form, Part 5, Notice Designating Reporter's Transcript. Skip this if you did not designate a reporter's transcript in Part 2. If you checked Box B and Subbox 1 in Part 2, you must fill out Part 5. Under Subpart A, check how you want to receive your copy of the reporter's transcript. Your choices are paper copy, electronic copy, or both. The cost of the deposit is the same no matter what option you choose, but the final cost of the reporter's transcript may be different depending on your choice. The only way to be sure is to talk with the trial court reporter. If the cost doesn't matter, check Box 3 to get both a paper copy and an electronic copy. That will give you the most flexibility when you prepare a brief. In Part 5B on page 4, fill out the table by listing every proceeding you want to be reported in the transcript. A full day means a day when proceedings lasted 3 hours or longer. A partial day is a day when proceedings lasted less than 3 hours. In the description column, you can be very brief. Descriptions like trial or motion hearing are fine. If you do not know the court reporter's name, you can probably find it by looking at the clerk's minute order for that day. If you do not know how to do that, you can call the clerk of the department where the proceedings occurred. In the Previously Prepared column, check Yes if you have a copy of a reporter's transcript for that day, and No if you don't. Under Item 7A, you tell the trial court whether the transcript includes or does not include all of the testimony. Here, testimony refers only to witnesses, including the parties being sworn by the clerk to tell the truth and then making oral statements about the facts of the case to the judge or jury. This includes when a witness is called to the witness box and answers questions from lawyers, parties, or the judge. This also includes when parties are sworn to tell the truth and tell their stories to the judge without using the witness box. Check the Include box if your designated proceedings include all of the testimony that was given in the case, even if you do not include other proceedings at which there was no testimony. Check the Do Not Include box if your designated proceedings do not include all of the testimony. If you must check the Do Not Include box, then you must state the points you intend to make to the Court of Appeal in the space below Item 7B. If you need more space, you can state the points on an extra piece of paper and attach it to the form. When your Form APP-003 is complete, you need to sign and date it. You'll file this form in the trial court. Do not file this form in the Court of Appeal. Thanks for watching this video on designating the record. If you need more information, you can contact your trial court or visit our website.